Good evening, everyone, and I'm happy to welcome you all for the IPNet's webinar, Challenges in Compliance Certificate under IBC. We are happy to have Shri G.S. Narasimha Prasad, MD, IPA ICMA, and Shri Ashish Makija, President, IPNet, with us today. IP network, in a short span of time, has become a buzzword amongst insolvency professionals across India. IPNet unites all IPs under one roof to meet all their expectations and their needs. The common needs of IPs are: 1. Enriching the knowledge; 2. Support in clarifying their doubts in IBC; 3. A forum to represent their grievances and obtain solutions. And IPNet satisfies all these three needs. The unique features of IPNet, I would say actually, one is that it is enriching the knowledge by discussing various topics every week. In separate study groups also, the subjects are discussed actually, conducting webinars on every week on topics addressing the key challenges faced by IPs. Each member of IPNet will have an individual login ID and can have access to all available resources to enrich his or her knowledge. In short, IPNet is a one-stop solution for all the needs of IPs. I'm sure all the IPs present here are all the members of IPNet, and if not, please join and enrich your knowledge. Thank you, sir. Now, I request Mr. Parag Singhal to go ahead with the IPNet presentation.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you, Mr. Parag. May I request Mr. P.T. Joy to introduce the chief guest?
Yeah, thank you, Mr. Ravichandran. Good evening. I have the pleasure and privilege of introducing a versatile personality. Mr. G.S. Narasimha Prasad is currently the managing director of the Insolvency Professional Agency of Institute of Cost Accountants of India. His academic credentials are: he is Master of Business Laws from National Law School, University of India, Bangalore, CAIIB from Indian Institute of Banking and Finance in the year 1992, BSc Mathematics from Bangalore University in 1984, Diploma in Financial Analysis from ICFI 1993 in the year 1993, Diploma in Business Administration from IGNO in the year 1995. He is a registered IP, consultant, trainer, experienced banker, and entrepreneur on the panel of registered IPs with the State Bank of India, Punjab National Bank, Canara Bank, Karnataka Bank Limited, and Exim Bank, apart from NCLT, with extensive exposure to CRP and related activities. With this, I introduce Mr. G.S. Narasimha Prasad. Thank you.
Welcome, sir.
Thank you.
Yes, sir. Over to Mr. Narasimha Prasad ji.
Thank you. Thank you, Mr. Ravichandran.
We welcome you, sir.
Okay.
Sir,
Thank
Ashish
you.
Bagija, sir, also here. And
Yes.
certainly.
Good afternoon, sir. Good afternoon, Mr. Maincha.
Good afternoon.
Welcome, sir. Welcome.
We met just about 2 weeks ago. He gave
Yeah.
us a very nice presentation on the future of IBC, or where IBC will be in 2030. I hope some of those who were there are here also, so they can recall. Thank you, Mr. P.T. Joy. Very kind of you. Very generous introduction. I must make one correction there. I am not listed or empaneled with NCLT now. I am not a practicing IP. I am just a registered IP. Yeah. Thank you for giving me an opportunity here. I was just seeing that presentation. I also know I've had several introductions with Ashish Ji, and recently with Mr. Ravichandran. Clearly, IPNet is doing a great job, and given the number of people who are on your should I call it, roles? I don't know, whatever this one is, that is the number of your members or and your associates across the country, because I see HIPAA there, I see KAPF there, and I believe there are several others who are you work on it. That model, I think, is a very smart model, if I may call it, that loose network of interested professionals and professional body associations of professionals, which together work only for mutual benefit, mutual interest, and purely voluntary way. I think it is sustainable. Ashish ji will know more about it, but I'm sure it is sustainable, and I hope it grows well. Yeah. Well, okay. Let's not make much of this one about this introduction into remarks, things like that. You have asked me to speak on challenges in compliance certificates under IBC. You see, I had one of the frontline regulators of IPs, so I can only undermine the importance of compliances. I can never overstate the importance of compliances as the regulator. And second thing is that I also appreciate the perspective of the IPs, which frequently comes through to me as in the form that compliance is a necessary evil. I do hear that frequently, and I appreciate that, is what I'm saying. I will only add to that and say that it is a necessary evil. It is not evil exactly. We should not call it evil, but it definitely is necessary. It does look painful at times or many times. There, I would be understating is I agree that at times it may look painful. Maybe you will feel that I'm undermining that. I'm understating that, right? Uh, but let me just get into, and I think you have some very eminent and experienced speakers here today to talk about the same subject, who will, I'm sure, Srimati Suhasini Ashok and Srimati Anuradha Bisani, special moderated by Mrs. Geeta Sridhar. I'm sure they will go into details of compliances, what kind of compliances and what is involved there and all that. They will not, so they will go into that. And so I will not go into what are the compliances, how are the compliances to be met, and what are the challenges in actually meeting those compliances, which are primarily in the form of reportings, filings and reportings. We have compliances to IBBI, the sectoral regulator. We have compliances to the frontline regulator of IPs, which is your IPA. Apart from that, IPs have the other statutory compliances, regulatory compliances, whichever is involved, taxation or MCA and other things. Now, in this, let me just go briefly into what's happening with compliances with the regulators, IBBI and primarily IPA. Now, you have IPs have compliances to both IBBI and IPA. And right now, as it stands now, there is quite a bit of repetition. What an IP reports to IBBI is also to be reported slightly in a different form or the same forms, but there is a process of reporting. Yes, I do agree. This is exactly what is being sought to be more corrected and is being done now. The process is very much on. One thing I can say is that IBBI itself and we at the IPA very much the complaints cost should be minimized as much as possible. You will be aware that recently while not very recently, it happened in September itself. Liquidation compliances reportings were put together in a new format, and all IPs are still in the process. I think it has been extended till March recently. And we have received a lot of complaints about why at all about the past and gone processes need to be reported when there are a lot of practical issues in reporting them online kind of thing. Then secondly, also on the CIRP compliances, we do get to hear frequently that it is all repetitions and then there are a lot of technical glitches and things like that. One is, I must tell you that it is still a process which is still evolving and which is still, there are a set of compliances that are required. That is simply because as the sectoral regulator, IBBI, and working with them, IPA, do require information on the processes that are happening, because it is IBBI which is responsible for dissemination information that's happening in the sector. So IBBI requires accurate, timely information. Fact is also that today IBBI is not getting to the satisfaction to extent of to the extent that it should. Let me not go. So the one thing is that liquidation forms have been consolidated and put into forms, which is happening. CIRP forms also, you would know that that a new CIRP forms have been introduced. They have the discussion paper was there, and then the suggestions were taken. And I think anytime now the new forms would be introduced, which are fully online. The benefit there is, unlike what's happening now, what you're all doing now, the information once captured need not be repeated again. In one form, it is captured. That is captured on the database, and that itself populates the rest of the forms that you may have to fill in the other this ones. And once you fill in some in the same form, for some reason, technical glitch, network issue, or whatever, it is lost. The complaints is not formed, filling in is not complete. The information is stored, it's saved. Whatever is filled in is stored, such that you don't have to repeat. So I think that is a major this one that has been achieved. Those of you who have been doing it may have seen that. Uh, the third thing is, I think you have necessarily this one about the half yearly reporting to IPA, which is where the IPA this one comes in. And you have this annual forms with this about the fees to IBBA. Now all of this is captured with at the time of renewal or issue of the AFA, which is where something like the headmaster catches the student who is not compliant, who is not passed, or who has bunked the classes and things like that. Now I can understand if the IPs feel that way. I can see that. But the point is, this is the point for review, whether the information that is to be shared by the IPs who are handling processes have come to IBBI, so that IBBI can, whatever the inferences IBBI draws, whatever the information that IBBI disseminates through its reports, whatever information that is with IBBI and IPA, for instance, is accurate and is timely, is complete. That's the whole purpose. IPs, you're all very experienced officials, and you very well appreciate, I'm sure, the importance of information, which is timely, which is accurate, which is complete. So my request to you would be to be a bit patient with the regulators today for a little more time. These CIRP, this one's forms are put into practice, which is anytime now, I think, maybe a month or so. I really don't have an update on that because it's happening at IBBI, but it should be soon. Things would become much simpler. And IPAs also, soon IPAs will also draw the information required from the same report. IPs will not have to report their respective IPA again separately. We know that most of the things are happening by emails, and let me confess also that it is not as if at IPA that we are able to go through all those documents that are shared by IPs. Our office is able to, our people are able to go through them and then make some decisions or make some inferences or so. We are not able to. That's the whole point. That's the purpose of creating templates of these, from which the data can be taken and information is generated from that, so that the right inferences are drawn at the right levels. I should stop at this. If there is any concern or any question that you would like to address to me, we can do that shortly for a few minutes, because I don't want to eat into the time. Primarily, it is about compliances. So I'm not really talking about compliances. Which are the compliances? I'm not talking here. If there is something that anyone would like to address specifically, welcome.
Sure, sir.
Okay,
Thanks for
I take it.
Yeah.
I take it, So let me not eat into your time. I'm sure Suhasini ji and Anuradha ji will have more practical things to share with all the members present here. Thank you. Thank you.
Thank you, sir, for setting the tone for today's webinar. And I'm sure that your some of the observations were really useful to the IPs. I request Ashish Makija sir to say a few words, sir.
Okay. Before I do that, I think Mr. Prasad, I think one of the important thing is, Parag, can you just unshare? Yeah, thank you. I think there is one observation in the chat box. If you can permit me to read it for you. Now, Mr. Arun Kapoor writes, one of the IPs is why the information received by IBPI through various forms is not auto-populated. So I think you have already covered this point, but can you just highlight it, sir, as far as auto population in the forms is concerned?
Yeah. Thank you, Ashiji. Yes, right now it is not auto-populated. You're right, but that is the exact thing. That's why I highlighted that when I was speaking, that auto-population is one thing that is happening in the new forms that are being introduced. I think many of you would be aware that drafts, these ones were introduced for suggestions from all the member IPs, from the IPs. So that is, those forms have already been completed in the IBBI. They would be released for compliance anytime now, I would think. So there the thing is, auto population is very much happening. It's very much happening. That has been tested as well. So that is taken care of. That is taken care of. Yeah.
I mean, if you can share, I don't know, we don't want to jump the gun, but when that new portal which we are hearing and the new forms uh, will be introduced, or what is the likely date? I mean, within 15 days, within 1 month, within 3 months. I mean, just a broad date. That's all. I mean, we don't want to put you to in a spot.
No, two things. Two things really. No, that I can be open about it. That's okay. So one thing is that two things. Uh, the new CIRP compliances, which is being prepared, that should fall into place anytime now.
Okay.
Anytime now, because IBBI is ready with it. I think this one is, I think it has been tested also. They had been shown in the demo. These ones were happening in some of the roundtables we had done. We had done also. IBBI itself had done. So that I would expect is being introduced anytime. But let me not put a timeline to it without knowing. I'm not in IBBI. I dare not speak on behalf of IBBI.
Right.
Right. So
So we
IBBI
can
is the sector.
Yeah, so we can expect it sooner, basically,
I
right?
think soon. It is not a long-term vision. Definitely not a long-term vision. So it's happening anytime soon. You also mentioned portal. Portal is different, sir. I must say
Okay.
portal. Yes, portal is being talked about. Rather, it is not. It is more than talked about. So there actually, recently, I think in that portal we are talking about is something that's happening at a larger level. What was initially thought about as, like, for instance, the IU was to.
Right.
IU has a this one, you see, the facility for IPs to manage CIRP liquidation and all that.
Yeah.
But MCA has put out I think, asked for EOIs. MCA will have an integrated portal which will include IBBI processes, rather IBC processes as well.
Okay.
And I think they have set a timeline of 18 months or so
Right.
for that to be in place. Many of those things are, and it is as much a question of integration of various process packages that are there, softwares that are there at various, like MCA itself has, and then IU has, and then other ones have, as much as developing some. So I think they've set a timeline of 18 months.
Okay. Chalo, great.
I think
Sir,
so, as
there
good
is
as
one,
the what.
yeah, there is one more comment from one of our IP members, Mr. S.K. Verma. So it's more like in this manner that there are certain compliances which are required to be done by the IPs. Can there be a system where a reminder can go to the IPs that look, of course, I understand half yearly return reminders typically go, but for others also. Or secondly, now one of our friends has mentioned here that in case supposing his form gets delayed, assuming he's not filed it, can another message also, or an auto email can come, so that at least heavy penalties are avoided. I mean, we're not putting the onus on you, the regulator, to remind the IPs, but if it's a matter of system which can be done pretty easily. So is it possible, sir, to do that?
I understand. I understand. This feedback came up when these were being discussed, actually. So when these were shown in our demos. So I think this part of reminder being sent. Okay. Firstly, the compliance is now, all the forms have been put together that it has to be done together in the following month before the 10th.
Right.
Not like as and when, and so I may miss the deadline, somewhere in the midst of all that I'm doing, I may miss this, and so I may be delayed, and so I may end up paying penalty. That is being avoided. So these ARP compliances will happen at the end of the month before the 10th of the following month. That's one thing.
Right.
Similar, same thing applies to liquidation compliances as well. That is one thing. And second thing is, so reminders. Yeah. So reminders, I think will have to, that have been, the feedback was already there. This feedback that, better there is a reminder, that I think would be incorporated, because it had come to the developer actually, to IBBI. So that would be taken care of. And
Okay.
of course, like you mentioned, for HYR and things like that, IPS do send reminders. Yeah.
True. Sir, one last thing before, because I think our learned speakers are also there. We don't want to encroach upon their time, but the last question is there a possibility to cap the late fees? Because you see, if it is on a daily basis running, I mean, there should be, like, supposing I could not file a form, say, 3 years ago. Now I have to pay a penalty of, say, 25,000 or 30,000 rupees. Is it possible to have a threshold or an upper cap? I mean, not to keep on as a continuing default or something like that.
I understand. I understand. I should first speak for the IPA. One is that we have a cap. See, only the HYR, this one, we have a cap. We
Right.
have a cap. It's a
Right.
maximum. Only thing is, we have many cases where the delay is much longer. So what do we do? So the cap is there, and so the cap is not felt penal enough that there are so many non-compliances. But that apart. So that we will do differently. There is a cap already. To my mind, yeah, there is one. I think there is no cap there. Yes, I know. We will bring in a cap there also. Idea is that in IPA
Right.
there would be a cap. That's one thing.
Ultimately,
I cannot really speak about the other this ones. Yeah.
well, the ultimate idea is not to penalize the IPs. The idea is to ensure compliance. So
Exactly.
therefore, I
Absolutely.
think with that idea, there should be a maximum
Absolutely.
cap so that IPs are not
Absolutely.
penalized for the past kind of non-compliances.
Absolutely.
So that was
Absolutely.
the
I would
idea.
also like to mention one thing. I
Yes.
can speak from our own IPS experience. The number of non-compliant members is quite large for
Mm,
fairly simple compliances. And for instance, HYR, for instance, it is just a question of putting in a nil report.
mm,
In spite of reminders, if IPs don't send.
mm.
And now it is not. Earlier it used to be, you had to pull out that form and then sign it and then scan it and send it, kind of a thing. Now it is online. That doesn't reflect well and cannot be justified.
I agree, sir.
That's and then we have quite a few, and we go through quite reasonably carefully wherever there is a penalty involved. We have refunded several
Okay.
members where there was justification. It was found that
Narasimha Prasad, sir.
Right.
Sir,
All
sorry to interact, sir, to interfere, sir. Sir, I really doubt whether the board themselves have any idea what is that form, why they are inducting that such kind of forms. Because the way in which that the formats have been designed, sometimes it gets irritated to file the form also.
okay, Mr.
Such
Rajesh.
nonsense information they are asking.
Okay, Mr. Rajesh, I think let's hold on. This question typically, I think the speakers will take up, because I don't think Mr. Narasimha Prasad is the right person to answer that. We don't have anyone from IBBI. Let's discuss amongst ourselves. If we are facing any issues, naturally we will make a representation to them. So
Do
we
let me
appreciate
know.
your
Do
concern.
let
We
me know.
appreciate.
Whatever you find nonsensical, for instance, like you mentioned,
Mm.
whatever you find is totally irrelevant. Why should we give it, or something
Right,
like that?
right.
Do let us know. Do let me know. We will
Sure.
definitely take it up in IBBI. We interact
We-
with IBBI very frequently.
That is why, sir, these seminars help, you see, to understand the IP
Yes.
issues, and then we will
Yes.
definitely forward it to you so that these can be complied with. Okay. All right. So,
Sure.
thank you so much, sir. I think let me just give a formal vote of thanks on behalf of IPNet and on behalf of all the members who are present here today, sir. It's my honor to extend my deepest gratitude to you for joining us today and sharing your insights. I think your thoughtful observations and the practical aspects of making compliances have actually set the tone for what promises to be a very, very engaging session today. And I must also acknowledge and thank our distinguished speakers, I would say, Ms. Anuradha Bisani and Suhasini Ashok B, who will be now taking the stage to share their experience and perspectives on today's topic. Well, all of us are eagerly looking forward to their valuable contributions. In fact, I will invite all the members to share their experiences also. And rather, let's find out a solution. If any issues are coming up, we can make a representation. We can approach IPS. We can approach IBBI also. I think they are very, very receptive. So let's try to sort all those things out. So thank you once again, Mr. Narasimha Prasad, for gracing this event and, of course, enriching us with your wisdom and experience. Thank you, sir. But before you leave, I think I'll request Mr. Parag to share on screen, sir, the memento for you, sir. And we request you to please accept it with our deep appreciation. We'll send you the hard version of this to you, sir.
Sure.
Thank you so much.
Thank you.
Thank you, sir.
Nice to be here. Nice to be here.
Over to you, Mr. Ravichandran, for
Yeah,
the
thank
further-
you. Thank you, sir. Thank you, Narasimha. Thank you, Ashish. Now, let me introduce the speaker of this today's session, Madam Suhasini. Suhasini is a master's in commerce and law, is an associate company secretary, advocate, and an insolvency professional. Suhasini has over 15 years of experience as company secretary, insolvency professional, and advocate. She has worked in many leading organizations, including Ujwan Financial Services Limited, and she has also worked in Bangalore Stock Exchange and Hyderabad Stock Exchange, and a broking house at Bangalore with a commodity trading company based at Singapore. She was a partner with one of the top insolvency professional entities where she worked on restructuring of companies under IBC. Currently, she is a founder and designated partner at P2S Niam Advisors LLP, who are the partners with L&Co LLP, a reputed firm and multidisciplinary consulting firm, providing services in transaction advisory, legal due diligence, risk advisory, financial reporting and advisory, ESG advisory, forensic accounting services, cyber security, IT risk, consulting, and digital transformations. Suhasini is currently handling as a resolution professional a large account for a resolution debt size of rupees 1,500 crore, managing a critical citizen-based governance company as a going concern. She is a liquidator for one company and 7 personal insolvency professional matters at NCLT. Suhasini is a triple gold medalist and university topper in LLB. I now welcome Suhasini Madam to take over.
Thank you, sir. Thank you for the long introduction. And small 1 or 2 things have been missed out. I am also an IP Net member and from South.
Obviously.
Yes. And I am also part of a transition group that is created by Ashish Makija, sir. And I express my sincere thanks to Ashish, sir, for his commitment to the profession IP and for his visionary leadership. He has exemplary initiative he has taken up, and this IPNet is a great platform where we are having regular every week webinars where a lot of practical things are discussed. And as everyone knows that Ashish sir has his quality of his webinars are very high. So hope as an IPNet member we will live up to his expectations. Thank you for this opportunity, sir. And thank you to sir. We have to our chief guest Subramaniam sir, and for your remarks. As you said, compliance is a necessary evil with which we have to fight. Everyone knows IP profession. IP is a fighter right from beginning of the process. So IP always fights, and IP will trample down the evil by being diligent and carrying on the process with necessary support from the expert professionals like Ashish sir and others in the webinar. So with short remarks, I would like to start the session. Basically, our session is on compliance certificates, challenges under IBC for the compliance certificates. So we will be touching upon what are the compliances under the CIRP process. There are 2 speakers. I'll be touching on CIRP process, and Anu Bisani ma'am will touch upon the topic of liquidation process. later on, finally, we will conclude on the voluntary liquidation process. So regarding the CIRP process, as many of the participants are aware, the once the section 7 or 9 or the 10 application is filed by the respective financial creditors, the Honorable NCLT, upon the adjudication of the applications, they admit the corporate debtor into the CIRP process. And in the section 7 application, the financial creditors will recommend insolvency professional who will be carrying on the CRP process. And under section 9, the operational creditor may or may not recommend the insolvency professional. And under section 10 also, it is not mandatory to recommend an insolvency professional. In case if the creditors are not recommending, the bench will appoint the insolvency professional from the empaneled list, which is published by IBBI. And once the application of the once the application gets admitted, an insolvency professional is appointed as an interim resolution professional for a period of 1 month, who will be taking up the compliances to carry on the CRP process in line with the compliance of IBC code and the regulations and all the laws applicable thereto to the respective corporate debtor. So basically, we will be touching upon the compliances under IBC and mainly focusing on the Form H compliance certificate, which is finally submitted to the adjudicating authority for taking up the for the approval of the resolution plan. So just a quick update on the compliances which the RP has to, the interim resolution professional has to take up once the CD gets admitted into the NCLT, into the CRP process. The RP has to immediately take up the public announcement and collect the NCLT order and issue a public announcement inviting the claims from the creditors, and immediately take over the control and possession of the corporate debtor, wherein currently, since IBC has into the effective from last 8 years, various checklists and processes have been evolved. So once the company gets admitted into CIRP, a proper checklist as per the requirement of IBC code and the regulations are evolved. And as per that checklist, immediately RP has to create an email ID once the CD gets admitted with the CD name, whatever is name of the CD or CIRP. The email ID will be used as a process email ID. And also, when IRP is publishing the public announcement, he has to fill in the form. The forms are prescribed by IBBI and it is available on the IBBI site. The public announcement will be issued wherein the process email ID along with the email ID which is registered with the IBBI has to be given. So like this, some checklist have to be prepared, and also RP has to prepare CDs. RP has to immediately do a ROC inspection and download all the documents regarding the company, and also ensure if there are any class of creditors, then ascertain that all those compliances. If we go in very detail, it will take a lot of time. I'll be just touching on the various process, some 5 or 6 heads where the process is carried on. Like initially on admission, the public announcement inviting the claims. Then again, a brief checklist has to be prepared by the IRP, which has to be shared with the the board of directors whose powers are suspended, and also the Panchanama. There are regulations prescribed for taking over the assets of the company, and the assets have to be taken over by the RP, physical possession, and also wherever the bank accounts are operated by the CD, RP has to give instructions to the banks. This is one level of compliance which RP has to ensure. And then comes the immediately after public announcement, 14 days time is given for submission of claim. And once the claims start coming in, then claim verification also is a compliance, wherein RP has to have a proper checklist for each kind of creditors, like financial creditor, operational creditor, statutory creditors. For verification of claims also, RP need to devise a proper, he has to designate, he has to have his team. Basically, when a company is a larger company, when the corporate data is a going concern, and with the claims size is more, then RP has to ensure that the claims are verified properly, and getting books of accounts and cooperation from the directors is very critical here. So for verification of claims, RP has to admit the claims based on the document submitted, and also as per the regulations, if books of accounts are given, it has to be verified with the books of accounts, and also the contractual terms with the creditors. This is one check in the compliance. So basically, the timelines which are prescribed by the CIRP, the timelines table also need to be ensured. As a good practice in our CRP cases, we have been presenting to the creditors on the timelines prescribed by CIRP, exactly what is the timeline prescribed and what exactly is the actual compliance. So this will keep a check for the RP's insolvency professionals to maintain the compliances timelines. And within 30 days, RP has to collect the claims. Here, RP's role is to collect the claims and immediately prepare the list of creditors and submit the list of creditors to the NCLT, file and IA for taking note of the list of creditors. Then immediately constitute the committee of creditors with the unrelated financial creditors, and within 7 days of constituting the committee, the RP has to call for the first COC meeting. Then again, if the IRP will consent, or he may propose to creditors whether he will be continuing as RP, or otherwise creditors may propose for replacement of IRP with another insolvency professional as RP. Then one more compliance comes is immediately after the first COC, appointment of valuers. So appointment of valuers is another compliance, and preparation of IM, then issue of Form G within the timelines prescribed. So earlier it was 90 days. Now the invitation of EOI is 75 days. Before that, the RP has to prepare the information memorandum, and RP has to prepare the information memorandum, and after issue of Form G. So like this, this is the second stage. So till here, whatever are the compliances as per the regulations, RP has to ensure that it is complied, and also to be recorded in the respective immediate committee of creditors. Then in the process, issue of Form G and preparing RFRP, and also one of the important functions of RP to ensure compliance, that he or she has a proper VDR room prepared, which will be a kind of drive which will be created, wherein the entire CD related documents and also process related documents are saved along with the IM and RFRP for the prospective resolution applicants to view and also submit their proposal to the company. And one more compliance is, whenever the RP has to verify if the financials of the company available, whatever available, if any, the assets, as per the balance sheet, if the company has around 100 crores and above, as per the balance sheet, the assets worth 100 crores or above, the RP has to have a marketing proposal discussed with the COC, and the marketing proposal and the document from the IRP to be discussed with the COC and approved for the resolution process. Then once the resolution plans are submitted, before the resolution plans are submitted, the SRS will have a due diligence. So when the company is a going concern, the SRS will have lot of multiple questions. So RP has to attend to all the queries of the the PRS, sorry, prospective resolution applicants, based on the company financials or whatever, as is various basis, whatever is the condition of the company. And if the company is a going concern, the assets details and also the company contracts, whatever are live projects company is running, all these details, the RP has to ensure these are all shared to the SRAs. Then once the plans, before issue of the final list of PRAs, the RP has to ensure Section 29A due diligence. So this due diligence is very, very critical. This is one of the important points in Form H compliance certificate, where the role of RP ensuring that there is no ineligible the resolution applicants entering the process. So here the due diligence has to be done by the RP support team in case if the prospective resolution applicants are big companies, then declaration can be, affidavit or declaration can be taken, and along with that due diligence, online due diligence, there are various mechanisms available through which section 29A due diligence can be done. This is one of the important functions, compliance function of the RP. So basically, whenever we are carrying on all these processes, there are certain specific forms which has to be submitted to IBBI and IPA after completing certain process. So while filing, as a good practice, what we were doing is, whenever these activity timelines were coming, like 30 days, 47 days, 75 days, 90 days, so we used to ensure that the CRP forms, when we are filling, we used to ensure that the team used to prepare the forms beforehand, so that we are aware that that activity has to be completed. So even along with carrying on the process, the IPAs have come up with very good compliance checklists that will help the insolvency professionals to carry on the process without missing the timelines. Basically, this every week we used to review these compliance checklists. This is one regarding the process. Then once the section 29A due diligence is done, then compliance of reviewing the compliance of the resolution plans. The due diligence has to be done by the RP reviewing the resolution plan terms. So the resolution plan terms has to be reviewed basically on the financials, operations, and the capability of the SRA to implement the plan. So the mandatory contents of the resolution plan as well as the prescribed regulation compliances has to be reviewed by the resolution professional when the resolution plan is submitted. So these are just a brief I have taken through on the compliances in the CRP process. Sir, can we have Form H to be shared, sir? Now we will be touching upon the Form H compliance certificate, which will be submitted to the adjudicating authority under Regulation 38(3).
I think,
Sorry, 39.
ma'am, I think you have the right to present it again, Form H. I think you have the sharing right.
You can share your screen as well.
Sir, I have joined from a different system. Can you share, please?
Ravindra sir, do you have Ravichandran sir? Do you have?
1 minute. I'm just trying.
I'll WhatsApp, sir. I'll WhatsApp that phone. Sir, I have shared the form to you, sir. Ravichandran, sir.
So Ashley ma'am, in the meantime, you can continue while the form is being shown.
Yes, sir. So, Form H is a compliance certificate which after completion of the CRP process, the resolution professional will be submitting to the adjudicating authority for approval of the resolution plan. And some NCLTs are insisting even when COC passes the resolution for liquidation of the company, some of the NCLTs are prescribing Form H to be filed with the adjudicating authorities. So the compliance certificate under Form H is filed under Regulation 39.4. If we see Regulation 39.4, thank you, sir. So compliance certificate is submitted under Regulation 39.4. So the compliance certificate has to be submitted to the adjudicating authority for adjudicating on the resolution plan application of the corporate debtor, which is filed by the insolvency professional on approval of the resolution plan by Honorable NCL, the Committee of Creditors. The Regulation 39.4 mentions that the resolution plan will be submitted along with the Form H and also with the details of the performance security. Performance security is the which is submitted by the successful resolution applicant as a commitment for the implementation of the resolution plan. Usually the performance security amount is prescribed in the RFRP approved by the Committee of Creditors. So the Form H has some basic details of the company. We will not go into the basics of basic details like name of the corporate debtor, then date of constitution. See, date of invitation of EOI. If we see the point, these are all calendar of events which you have to, which the IP has to fill in, like date of appointment of IRP, date of constitution of COC. Then if we come to the point number 9, date of issue of invitation for EOI. So the EOI would have been issued multiple times. So RP has to give the details of how many times the EOI were issued. Then when we come to date of invitation of resolution plan, this also, whenever the date of inviting the resolution plan from PRS has to be given. This is as per the point number 9. This details also will change in the point number 11. Sir, if you go down, date of filing. Then when we come to point number 15, date of expiry of 180 days of CIRP. Here we can we have to give all the details of extensions taken or exclusions given for the CRP period. Sometimes 180 plus 90 days, then again the COC can go for up to 330 days. And even if any appeals are filed or any stay on the CRP process, that exclusion application, whatever exclusion we get from the adjudicating authority, those details have to be filled. Then fair value, liquidation value. Fair value, liquidation value, if there are two valuers, or otherwise if there is a significant deviation in the between both the valuation reports, then COC, then RP will appoint a third valuer. Then the average of the nearest to two valuations will be taken. So fair value, liquidation value, the RP has to give here. And the number of COC meetings held till the filing of the Form H, we have to mention clearly here. After filing Form H also, there may be a COC, there may be COC meetings. So here we have to clearly mention number of COC meetings held till filing the Form H, till the date of Form H. Yes, sir. We can go down, sir. So basically, why we are touching on the Form H is the Form H becomes this Form H only transpires into the NCLT approval of resolution plan order, and this Form H is sacrosanct for the NCLTs. The RPs has to ensure that the form is meticulously filed. Most of the times, some clerical errors also will creep in. So we have to ensure that double check with the team members while filling the details. And also there should not be any inconsistency between the forms which are filed with IBBI and the data in the Form H. There should be uniformity, because again these Form H details will be filed with IBBI in the forms. So here NCLT is relying on the certification of the insolvency, the RP, that RP has examined the resolution plan, and also on the Section 29A compliance. So basically, when the resolution plan is filed with NCLT, the NCLTs are checking on three things. One is whether the feasibility and viability of the plan is reviewed and discussed at the COC meetings, and whether the Section 29A diligence is done, and whether RP is certifying on that point. And one more important point which the NCLTs are checking is the implementation of the plan, the management control, and whether the RA has the plan terms which RA has proposed as a smooth implementation of the process. So can just little zoom in this point, the above point, yeah. So just above point, fifth point, we are still there, yeah. So one important point here is the RP is again certifying the resolution plan complies with all the provisions of IBC and regulations, and does not contravene any of the provisions of the law for the time being in force. This is very important here. See, as an RP, we are certifying that the resolution plan is complying with all the points, with all the provisions of the law for the time being in force. So this is discussed in one of the judgments in EBIX Singapore. Basically, resolution plan is a binding contract. The features of binding contract, again, contract should have all the requirements under Indian Contract Act. That is, the resolution plan should not have any terms which is against public policy. Again, if it is against public policy, it is void. Then this is compliance of all laws, which means we have to ensure that there are no prohibitory laws or the resolution plan terms does not have any prohibitory laws. And suppose, like, for example, if the CD is into distilleries, then it is a regulated business. The requirement is they have to take prior excise department approvals. So these are like, and the RP has to ensure that anything which is not circumventing the applicable laws has to be ensured. And one important thing is regarding the section 29A, which is again a very vast topic, which we will not be touching here. So the eligibility under section 29A is the RP has to ensure that the applicants who have submitted the plan are eligible under section 29A. And regarding this, affidavit has to be collected from the prospective resolution applicants. Then RP has various methods to check on the diligence of the PRAs. Then the third point is the resolution plan has been approved by COC in accordance with the provisions and of the regulations, that is by 66% of the voting, and also feasibility and viability requirements as specified under the regulations. Here again, just I will touch on requirement of the regulation. The voting, the requirement of the resolution plan approval is by 66%. The financial creditors, it has to be approved by 66% of the voting. If there is a situation, if there are two plans which have acquired the same voting, then there is, as per CRP regulations, there is a tie break formula. So before voting, the RP has to ensure that COC decides on the tie break formula. So when there is a tie, how the plan will be evaluated. Suppose if two plans are put up for voting, one does not receive, one receives around 62%, the other receives again 52%. Then RP has to again put in the both the resolution plans for approval. Sir, can we go for next point? Sir, can we go to the next point? Yeah. So the list of, then the fifth point is the list of financial creditors of the CD being member of the COC and distribution of voting share among them as under. Here, the details of the creditors who have voted for the resolution, who have voted, dissented, abstained, all these details have to be given. So in our case, what has happened is, in my case, we have around 56 financial creditors, wherein the voting details were given here. When here the RP has to ensure, in case CD is a going concern, has some live contracts where the bank guarantees are given for some projects, and the BGs have been the BGs the BGs have been invoked by the respective parties, and the bank comes back to you and submits a revised claim in the process. And now the as per the new regulations, whenever the creditors are submitted the claim after issue of RFRP, the earlier whenever there is a condonation of delay in filing the claim, the creditors used to go to NCLT and seek condonation of delay and file their claim with the RP. Now the IBB, the code casts vote on the casts duty on the resolution professional. So now the resolution professional, upon receiving the revised claim from the creditor, he has to classify whether admissible or non-admissible. And once it is admissible, he has to recommend to creditors to file and recommend, the creditors have to recommend for filing an application with NCLT for condonation of delay in filing the claim. So basically, in our case, what has happened, for the CD is a going concern, and the one of the bankers, in their case, the BG was invoked, and they have submitted a revised claim, which has significantly increased the voting share to the creditor. And the creditors were not willing to treat this claim into the list of creditors. They have voted against this. They said this is an inadmissible claim. But however, the bank is taking the hit. So as an RP, I have filed an application with NCLT with the revised details of the creditors with the bank whose BGs have been invoked. So when I have filed this compliance certificate, in Form H, I have considered the revised claim of the bank, which was submitted later. However, the application was pending with the adjudicating authority for condonation of delay. So the voting share which was taken for one bank was different in Form H, whereas in the COC meetings, the voting share was different. So the NCLT technical member has raised a claim, and in one of the hearings in the resolution plan IA, he has raised a query and he has sought clarification from me to file a memo regarding the difference in the voting share in the COC meetings and in the Form H, which is captured at the 0.5. So this is one critical point where although we have given a clear, here we under this point, we have given a clear note that the voting share of one of the creditor is due to invocation of BG and resubmitted the claim, and the application is with NCLT. But however, for distribution purpose, it is considered in this Form H. So after we submitted the clarification, NCLT has duly considered and recorded our oral submissions, and the plan is approved. And at sixth point, the resolution plan includes a statement under Regulation 38(1)A as to how it has dealt the interest of all stakeholders in compliance with the court. Here, as per Regulation 38(1)A, how the interest of stakeholders, that is, how the operational creditors' claims will be paid, how the dissenting FCs will be paid, how the stakeholders' interests are taken care, that we have to just mention the clause number in the plan. Then the amounts provided for the stakeholders under the resolution plan. Here, basically, the RP has to ensure that whatever the amount claimed, final amount, whatever is this has to be taken from the latest list of creditors. Because the once the amounts are given here, then once the plan is approved, then again it becomes difficult for during the implementation of the plan. So the whatever the amount claimed, admitted, and whatever the amount provided against that admitted claim has to be given, and the amount provided to the admitted claim amount. Here, the percentage in the last column, what is the amount provided against the admitted, that percentage we have to give. This table is very important because this we are going to report to IBBI also. So ensure that we are maintaining uniformly everywhere as per the resolution plan, approved resolution plan terms. And the balance, whatever the admitted percentage, the balance becomes the haircut. Sir, can we go down? Okay, after the table, can I know? The interest of existing shareholders, how it is going to change. Here we have to give, in case of MSME promoter submitting the plan, the MSME promoter may or may not give the extinguishing of the shares. So those details has to be captured correctly at the point number 8. And when we come to point number 9, then the compliance of the timelines, whatever compliances, whether the plan has that compliance, whether it is complied or no, and what is the clause number of the plan, that has to be given. This is as per the actual dates has to be as per the plan terms, the details have to be given. Yes, sir. Next. Then the CRP has been conducted within the timelines. Then again, whatever are the timelines indicated, we have to give the actual dates. In case if the form G is issued 2 times, 3 times, then if the date for submission of resolution plan is extended, that multiple dates we have to capture here. Yes, sir. And in case if any specific regulatory authorities permissions, approvals are required, those details of nature of approvals, name applicable and name of authority who will be granting and when it will be obtained, all those has to be captured. Usually NCLTs are giving 1 year time to the SRS in this regard. And see, this is one of the important points as the 12th point. Here, Form H provides the resolution plan is not subject to any contingency, or the resolution plan is subject to the following contingencies. Then we have to elaborate the contingencies. For example, in one of the NCLT Bangalore cases, one of the real estate company where only the home buyers are the financial creditors, and the resolution plan was given subject to contingency that there was a litigation on the land. Land is only the asset. Subject to that civil court giving a favorable order, then the resolution plan will be implemented. So these contingencies, with these contingencies, the plan was approved by COC, but however, NCLT Bangalore has rejected. So basically, when the form itself is providing for a contingency, but NCLT Bangalore's, NCLTs are not approving the contingent plans. So this maybe Ashish sir can clarify to us after the session. So in case during the process RPs have any deviations or non-compliances of the provisions of the IBC, whether still the deviations or non-compliances are there or whether it is rectified and what is the reason for non-compliance, like example, valuers not appointed within the timelines prescribed, then when they were appointed and what was the reason for not appointing, all those details have to be filled. Then when the plan has to be filed before 15 days before expiry of CRP period, then here the details as per the extensions or exclusions, the details have to be filled. Then again, when then again regarding the PUFE application, the details had to be provided on the avoidance transactions. And basically, this is the entire transpiring the entire process into this form so that NCLT will understand how the process is run. Then when the resolution plan is considered for voting, that time along with the voting on the resolution plan, the committee also need to approve resolution for liquidation of CD as a going concern, estimated liquidation cost, then contribution towards estimated liquidation cost. This is so that when the liquidation order is passed, these are already considered by COC and submitted to AA, so that within 7 days of liquidation, the liquidator has to take up all this. So this sale of CD as a going concern, all these resolutions are considered. If COC approves, yes. If not approved, then no. All these resolution details have to be provided. Then in case, then during the CRP process, while approving the plan, the resolution professional has to put up to the COC the fee payable to the liquidator, whatever as per regulation 39D or whatever the COC deliberates and decides. Then the details of RP will be given. So I just want to share one NCLT very recent order regarding the Form H only. This order is delivered by NCLT Bangalore on 28 November 24 in the matter of Omkush Infrastructure Private Limited. Wherein the NCLT was going through the relevant columns of compliance certificate under Form H, where they examined and noticed that Regulation 39(3)(a), that is whether the resolution plan addresses the cause of default mentioned in Part E, the NCLT observed that it relates to implementation of the resolution plan and it does not deal with addressing the cause of default. And also the non-compliance of Regulation 38(3)(a), 38(3)(b), that is regarding the compliance of affidavit, whether the resolution plan demonstrate feasible and viable. Regarding this compliance, when NCLT bench has looked into the feasibility and viability of the plan consisted only about the how the management control of the CD will be after the approval of the plan. So noticing that there is a deviation in the compliance of regulations 38 in the Form H provided by RP, NCLT has rejected the resolution plan. So in view of these non-compliances, the resolution plan is not meeting the requirements of Section 32F and also the IBBA regulations, that is non-fulfillment of requiring regarding the cause of default and feasibility and viability of the plan, Regulation 38(3)(a) and 3(b), and absence of due diligence report. The NCLT has given an order saying that the resolution plan cannot be approved as the requirement of Section 30 and regulation have not been complied. So, just want to conclude, we have only touched upon whatever the basic compliances required in the process, and finally the Form H, which is very critical when the resolution plan is submitted to the adjudicating authority for approval of the plan. What are the mandatory contents and what exactly the NCLT will look in the terms of the plan. And while filling the Form H also, the numbers have to be clearly whatever the financial proposal proposed by the SRA, those details also need to be captured. In one of the Hyderabad NCLT cases, in one NCLT order, the numbers of the creditors have been just clerical error. Some numbers as per the resolution plan were not filled, and the RP has to go to the NCLT and seek directions asking for a corrigendum order to the resolution plan. So while filling this form, compliance certificate with to be filed with the adjudicating authority, RP has to exercise due care and diligence and ensure it is filed with the correct information as per the CRP process, and also ensuring the compliance of applicable laws and regulations. Thank you. Thank you, sir. Thank you for the opportunity.
Thank you, Suhasini, for your wonderful presentation. I now we will invite the second speaker.
Excuse me, sir. Can you please unshare your screen?
Yes, sir. Sure. Yeah.
Yes, sir.
Can we due to time, actually, can we invite the second speaker, Madam Anuradha Bizani? Madam Anuradha Bizani has 22 years of rich experience. She is a MCOM, FCS, MSc, MSc in Psychology, LLB, is an independent director and also an insolvency professional. She has a rich experience in speaking to in various forums in ICSI, Federation of Telangana Chamber of Commerce, and other industrial associations. We welcome you, Madam Anuradha Bizani, and kindly go ahead with your presentation, Madam.
Thank you, sir. Thank you so much. And thank you to IPNet for this opportunity. Thank you to Suhasini also being my co-speaker. She has set the stage for me to continue on this. Suhasini has touched upon a compliance certificate under CIRP. I will be taking up same Form H. It is still called compliance certificate, but it is under liquidation. So the regulations are different. And may I request Ravi sir, should I do this screen sharing, sir?
You can do, madam. In case of difficulty, we will. I think you have
Okay.
the right. Yeah.
So this Form H is visible to all of you, sir. Sir, can you confirm?
Yes, ma'am, it is visible. Please go ahead.
Yeah. Okay. So this is under Regulation 45, Sub-Regulation 3 of IBBI liquidation process regulations that this form is required to be filed once the liquidation process is over. This has to be filed along with the final report prior to dissolution. Now, see, earlier in the sense, we do not know how to use this checklist at the end of it. So I request all of you that as and when you start your liquidation process, see to it that you take this checklist as your first stage of beginning of the liquidation process. And as and when the dates are occurring, go on filling these dates. Always keep this checklist with you from the day one. So don't think that at the end of it, I will fill the form, because see, if you look in Form H of compliance certificate here, there are two parts to it. One is entirely about dates. So around 46 dates you have to give, and in that you have many other dates. And then you have the second part where you have to give the amounts which are involved in the entire liquidation process. So if you can keep this itself as a synopsis for your entire liquidation process, it will be easy for you. So from the day one, start with compliance certificate. So the day you get your assignment, you can fill the name of the CD, you can fill the case number and which bench of NCLT is dealing with it. Then LCD is there with you, date of appointment of liquidator, commencement of CIRP, and IP details. So all this you can fill on the first day of your assignment. So keep this checklist as a quick referencer for you for the entire liquidation process. Now then, we have date of publication of public announcement. I will, since the time is very less, I don't want to run through each and everything. But there are certain dates which you have to follow. Like, for example, public announcement has to be done within 5 days of LCD. So ensure that has been done. Okay, then if you look at the form here, entire thing is about dates. Until 40, except this 45th, everywhere else we are dealing with dates only. So if you have any issues here, let me know. Otherwise,
Madam, this point number 9.
Point number 9. Yes, sir.
It talks of date of
Intimation to registry and IU, if any, about commencement of LCD.
Registry means the ROC that INC 28 we are filing. Is it the same date?
Yes, sir. This is registry is with respect to the NCLT registry, and we are talking about the IU here. So if at all you have informed them about the commencement of liquidation, that date can be given here. Otherwise, see what is happening is earlier, since this is an evolving jurisprudence, earlier this form was not in this form. Okay, lot of additions have been made, lot of regulations have been evolved and added. So those who have initiated their liquidation process in say 2017, 18 and still it is going on, like in my case, I will have difficulty with all these provisions because these provisions were not applicable when the process was initiated. So obviously I wouldn't have informed them. But in any case, if it is applicable, write the date. Otherwise, just write a dash.
Okay.
Then, okay, a typical thing here in point number 10 is observed date of handover of charge by RP. If the RP and liquidator are the same, then the date can be when the charge is taken over as liquidator. There was a case where the liquidator was appointed and he expired, and the next liquidator was appointed. So the question was which date to write here. Okay, so we said we will write both the dates. We will write from RP to the erstwhile liquidator, from the erstwhile liquidator to the current liquidator. So write both the dates. It is okay to give extra information than to hide the information. As and when, see, when you are in doubt, give the information. That's the policy adopted. Okay. Then we have date of appointment of registered valuers, and in case you have uncalled capital, this which is not there in CIRP form H will be here. Date of notice of uncalled capital. As you know, when the company is about to be closed or dissolved or liquidated, at that point, we have to consider what is the liability of the shareholders. So in case there is an uncalled capital, even until the date of liquidation, then it is the duty of the liquidator to call for that uncalled capital and see to it that the shareholders contribute to this. Then, of course, you have date of realization, date of opening of liquidation account. In case you are continuing with the same CIRP account, write those details and say that CIRP account continued as liquidation account. Otherwise, if you are opening a new account, give the details of those accounts. Then date of constitution of consultation committee. See, though it is called consultation committee, it is stakeholders consultation committee as per 31A, I believe. So date of constitution you have to give. Then number of meetings. See here in this column of 17, you are supposed to write only the number of meetings. You don't have to give the dates here. The dates will be given in the final report, but not here. So just write if you have held, say, 10 meetings, 12 meetings. As you know, the meetings also depend on quarterly. One meeting is necessary. And within the previous meeting and the next meeting, there should not be a gap of more than 30 days. However, if the SCC has approved for a longer period, you can go ahead. And within 7 days from the date of LCD, you should have had your first consultation committee meeting. So all these details, as and when you start filling up this form from the day one, you will have clarity at the end of the process. So start from the beginning. Then date of submission of list of shareholders, stakeholders to A. Date of, see, this 19th point is removed here, but ensure that you are following the same checklist. If you put it in Excel, then if you go with the dates, with the numbers, you might say that after say 18, 19 is not there and you might put 19. Then it'd be a lot of confusion. So just retain this format. Do not do anything with the format. If you want to add anything, simply go at the end of it, just add the column. Don't add the number there. Just add the row and the column and you can write what you want to write. Then date of a preliminary report and asset memorandum, fair value, liquidation value, date of public notice, date of the order to dispense with public notice for auction. See, earlier what happened in 23 and 24, if you see, they have said public notice. Earlier, this word was public announcement. So now they have changed it to notice. So if you have given the public notice for auction, if you have given more than one, just go enter there and add the number of rows. Do not add, do not change this number. Just add the number of rows here and give the public notice auction dates. In case there was an application to adjudicating authority to dispense with the public auction notice, then you have to give that date also. Which scenarios will have that? When suppose the goods are perishable in nature or in nature where the deterioration of value is happening. In these two cases, you can consult with SCC and go for a private sale. However, if you do not want to go for public auction at all, then you have to necessarily apply to the adjudicating authority for dispensing with the public notice. Okay. And then date of permission of A for physical auction. Physical auction, though it is not in the regulations or in the section, it is very much there in the Schedule 1 mode of sale. There it has been said that in case you feel that the physical auction is a better option for fetching more asset value, in that case, make an application to the adjudicating authority, get their permission, and then go for physical auction. And for private sale, as I said, if there are three conditions, either you directly go to the adjudicating authority stating that, we have identified certain buyer and giving advertisement and all will cost us more because the value of the asset is very less. So I can sell by private sale. You take the permission there. Or when the goods are perishable in nature, or when there is a deterioration of the value of the goods if you hold it for a longer time. In these two cases, you can, don't have to go to AA. You have to just consult with SEC, take their permission and do the private sale. Okay. And here, date of permission of AA for distribution of unsold assets to stakeholders. Sometimes what happens, there are NRRA, not readily realizable assets. So at that point of time, it is very difficult for us to close the liquidation process because that might take a longer time and there is no definite timeline. And as we know, our fees is dependent on the value that we realize plus the timing. And the liquidation process itself is supposed to be completed within a year. So where you feel that certain unsold assets or you are not able to sell them for whatever reason, then take the permission of the AA and distribute it to the stakeholders itself. So that date has to be written. Then you have this unrelinquished security interest. Yeah, this is section 52 and 21A, regulation 21A. So that date has to be given here. Modified list of stakeholders in case there is addition or subtraction to the list of stakeholders. Earlier in the SEC, if we know, there were only 7 members at the max that you could have had in SEC. But later the regulation was changed. Now all the creditors, all the categories are supposed to be in the SEC. So in case there is addition or deletion of the members in the committee, you have to inform them. Then date of first realization, second realization, distribution, all these have to be given. Here we are talking only about dates. Okay, further we move, we will give the values also. Now date of quarterly progress report, as we know, regulation 15 is the enabling clause for filing of progress report. And at the end of every quarter, at the end of every financial year, the 4th quarter, we are supposed to give the audit report as well. Now there is a date of submission of asset sales reports to the adjudicating authority. As and when you make a sale, you are supposed to maintain this asset sale report. And these details have to be submitted to the adjudicating authority. And the date, here they are only asking about the dates. Okay, so all the quarterly progress reports, how many ever you have filed, financial year 1, financial year 2, whenever a financial year is over, it has to be accompanied with the 4th quarter report, audit report also. Then date of intimation to statutory authority. Now, yesterday we were discussing in one of our meetings. So why are we supposed to inform to the statutory authorities? Okay, one, because now there is a new provision where it says that whenever LCD is starting, you better inform to the statutory authorities because they're not keeping a track of what is happening. In fact, we are supposed to inform to all the stakeholders. However, one of the participants in our meeting, he was telling, since it is placed at the end of the report, should we think that this date of intimation is not about the commencement of LCD, it is about the filing of the dissolution report. So if anyone has any clarity on this, what is the date of intimation, about what are you giving under this column? If anybody can share what are you doing, I will be happy to let.
So far, I have not handled any liquidation case, but to my understanding, it is the intimation of liquidation. Just like commencement of CIP, we are informing to the statutory authorities.
Right, sir.
Say all these, apart from that, I inform to other authorities like LCT board or very so many other authorities.
Yes, sir.
Right?
That's
My
why
income
we
tax
have
is
an
already
option
paid.
here with others also. So other than POPSI.
Yes.
We
I
can have
feel that
electricity department.
we inform the government departments as soon as we start the liquidation commencement.
So even, I mean,
So that they will file their claims.
Yeah.
Later, there should not be any problem.
Correct, sir. And now there is a new provision wherein it says that even if they are not filing the claims, if they have filed the claims in CIRP, those same claims can continue in liquidation also.
This is similar, madam, similar to CIRP commencement.
CIRP, right?
For the liquidation commencement also the same is applicable.
Yeah, okay. Then we come to the date of deposit of unclaimed dividends or undistributed proceeds. Now this is under regulation 46, where there is a procedure which has been prescribed and details of the same thing will be given even at the end of this report also. So we will discuss it there. So then amount deposited into corporate liquidation account. So whether it was unclaimed dividends or it was undistributed proceeds, or it was any other income which is referred under 46, 2, 3 or 4. All these details have to be given. Except these two, except this 45, everywhere else we are only giving dates here. Okay, then date of submission to the board and the authority under regulation, sub-regulation 5 and 46. So this again relates to the corporate liquidation account. Then date of final report to the AA. So final report, the enabling regulation is regulation 5, where under reporting, this is the powers and duties of the liquidator. Under that, it has been prescribed that the final report has to be filed with AA. Along with final report, Form H is a compulsory attachment. Now, here now we are coming to the second part of the Form H. In the first part, we have only given dates. Now, in the second part, we are giving the details of the assets as per asset memorandum and final sale report. So here we are giving the serial number, assets, mode of sale. So was it a private sale, physical auction or e-auction? All the three have to be mentioned, whichever mode we have used. And then estimated liquidation value of that asset. And what was realized and when it was transferred to the, when were the proceeds transferred to the liquidation account? Okay, then we have liquidation value of the liquidation estate. So amount realized from sale of liquidation estate and the amount distributed as per 52 or 53. So this is the column where 52, we have section 53 subsection 1, A, B, we have all these categories. So here we are supposed to give the amount claimed, admitted, distributed, so the percentage. So here we will know actually how much by, see, all this is given only for the reference to the adjudicating authority. But more than that, it will help us to know how the entire process we have conducted. So for us to know whether, the total distribution, suppose somebody asks you, so in your liquidation, what was the amount of percentage that you have distributed? You can know it from here itself. Okay. Then the liquidation process has been conducted as per timeline. So as per regulation 47, we have plethora of timelines where you start from the public announcement. The LCD will be the T is equal to 0. And from there we have everything. So plus. So you use the timelines which are there in 47 and indicate here if you have followed the timeline and in case there was a deviation, you have to report it here. Okay, then the dissolution application has been filed before expiry of period of 1 year or after expiry. See, we have a concept of prior dissolution also. So have you followed that, or your liquidation process itself was completed before 1 year or it was after 1 year? And in case you have sought any extension, specify all those details. Then in 8, we give the details of applications filed in respect of PUFE transactions, all the avoidance transactions. So it was all the 4 sections. When did you file it? If at all the order was given, and what was the brief of the order? Like, you have to just see, even though there is no concept of extra attachment to this form. However, when you're attaching extra details, nobody is objecting, even adjudicating authority is not telling anything. So in case you're not able to write everything what is given in the order, you just write here the crux of it and say the order has been attached for quick reference. and all undischarged or matters pending before any court or tribunal relating to CD, if any, has been reported to AA. See, generally what happens, if the company is sold as a going concern, then either we assign these things, the court cases which are pending, either to some stakeholders or to the buyer who is willing to take these cases. In case neither we have assigned it to the stakeholders nor to the buyer, in that case, you have to still report it to this adjudicating authority. What are the pending cases? In fact, we have tried doing that, but when the pending cases are there, we are not supposed to file this form. Either it has to be assigned to somebody, or if it is sold as a going concern, then the bidder has to take over those cases. In case they have not taken over, we are still supposed to report it to the adjudicating authority. Now, one peculiar thing I want to tell here in point number 10. There was a disciplinary action against one of the IPs because this form, after filling everything, was signed by the IPE and not the liquidator. It was signed by the insolvency professional entity and not the liquidator. So there was a disciplinary action against that person, and of course he was penalized, and his license was cancelled for 6 months and whatever registration. So be careful here when they are telling. See, they are telling I means as an individual. It's the name of the liquidator, not entity. So see to it that all these forms are signed by the liquidator itself. Okay. So this is the form that we were talking about. I think, sir, I am within the time, 5:45 it is. So in case anybody has any questions, I'm free to answer here.
Thanks a lot, madam.
Thank you, Anuradha ma'am, and thank you, Suhasini ma'am. That was really, very, very intricate presentation, because you touched upon every bit where we will get stuck, and then you ensured that it is all answered. Now the floor is open for questions. Because I don't find any questions in the chat box, so I request the members to ask the questions one by one, and the speakers would be too happy to answer.
We assume either we were too good or.
I have a question, madam.
Due to time constraint, we couldn't complete voluntary liquidation compliances.
So and we had to really rush through
maybe
this.
We can cover later. But any questions regarding voluntary liquidation process compliance?
There is one question from Mr. Himanshu Bindal, please. Himanshu ji.
No, that was just regarding that voluntary liquidation form. So I think she already I think we cannot cover within the timeline. So it was given to voluntary only.
So what is your query, sir? Maybe I am available, and also my team member Shavant, who is regularly filing the forms, is also available. So we can answer, sir.
Not query, just wanted to cover because I have not filled that form, but wanted to fill. So if it could have been touched upon, then it would have been great. But anyhow, that is fine.
Okay.
No query, specific query as of now.
Yeah, sir, in chat box, I'll share my email ID. You can contact us. We can clarify your query regarding that filling or filing of forms.
Yeah, thanks.
Yeah, Suhasini, I have one question in CIRB.
Okay.
That one clause you have stated about the contingencies, and if it is any contingencies, elaborate the contingencies.
Yes, sir.
Is it contingencies include conditional resolution plan, or contingencies is different from the conditional plan?
Sir, contingencies or conditional plan or contingencies are different. Basically contingency is happening or non-happening of a specific event. That is contingency. Like in one case, I've just mentioned that in real estate company, the title was litigated in the civil court. So the plan was proposed based on the outcome of the litigation. The resolution plan will be implemented. This is contingency, happening or non-happening of the event. So conditions are different.
But as you given an example, it is like a condition only, no? If that has happened, my plan is been considered. Otherwise, my plan is not no more valid. But how the civil dispute can be taken a longer time, till that time adjudicating authority will consider that plan or approve that plan.
Sir, in that case, adjudicating authority has rejected the plan. They have not approved the plan. Yeah.
So then it is means adjudicating authority consider as a conditional plan.
Yes. Because
Madam,
of contingency happening or non-happening of an event.
Yeah.
Madam, a conditional plan could have many kind of conditions, and one of those could be these contingencies. There could be conditions other than contingencies.
Correct. Yes.
And whereas contingencies, all contingencies are subset of conditions, but conditions are a superset of
Correct.
that's
Yes,
how,
contingencies can be conditional, but conditions are not contingencies.
not necessarily all conditions.
That specific event, that specific requirement is there in conditional plan.
Yeah, but it seems that RP has to be more cautious to identify between the contingency and condition before placing the plan before the COC and also the adjudicating authority.
Yes, sir.
Yeah. Okay. Thank you.
Makija sir, I have a question for you. On this contingency thing, sir, how would as an IP, I think both the IPs have shared their experiences and what their experience was with respect to NCLT. But then, as an advocate or as a senior person in the system, can you throw us some light on how this has to be looked in and how this should be treated, sir?
Okay, typically, you see the plans which come, they should be absolute. They should not be dependent upon any condition. That is the first other thing which IPs have to check. But there are certain things like even if you look at section 31, now 31 also says that supposing, assuming like it's a real estate project. Now, real estate project, if supposing SRA comes, naturally he has to take permission, isn't it, to before he starts construction. Similarly, supposing you are taking over a telecom company, you require a permission of, say, a TRAI. So those permissions which are required are not conditions per se, because section 31 clearly gives 1 year period of time to the SRA to obtain all those permissions. So we'll have to really identify what are simply the permissions required under the laws, or they are conditional plans that subject to happening or non-happening of an event or something like that. Then it becomes very difficult for NCLTs to approve it. They will never approve it. As Suhasini clearly mentioned, I think NCLTs are not in favor of approving such kind of plans. Okay.
So
thank you, sir. One minute.
From my side, Madam Anuradha presented this Form H actually, that serial number 27, date of permit of AA for distribution of unsold assets to stakeholders.
Yes, sir.
In fact, I had one case actually where the land was not contiguous and I wanted the stakeholders to take back the asset actually. But then NCLT did not give the permission and then my application was rejected and I was asked to somehow sell the land actually. Just whether anyone can share the experience actually, because this column has not worked for me actually with the NCLT.
Sir, this compliance certificate is filed only after everything has been done. It is like a closure report, right? So here, in case a permission has been sought and it was given, only then this date has to be filled. However, as you said, yeah, your experience has been that even after going to the adjudicating authority, they rejected your application and they asked you to sell it. So obviously you couldn't have completed the process within the timelines.
The reason was that how a financial creditor can take over the assets of a borrower. That was the reason.
Ravi sir, actually, I'll add one more point to your thing because you missed one point that originally they did not hand over the asset to the liquidator. And then subsequently, after a span of 4 years, after Ravichandran sir's follow-up, then they came and said, we cannot sell, so you better take over. So that was the base issue in that.
Oh, and another thing is you have to look at Regulation 38 also. Regulation 38 clearly says distribution of unsold assets. Now, if you have made an attempt to sell the property, you are not able to sell it, say 1, 2, 3, 4, 5 auctions you have done, then probably NCLT may consider, okay, all right, you can distribute in kind rather than selling in cash. But if you have not attempted for the first time, I don't think NCLTs will concede to that. So therefore, please look at Regulation 38 very clearly. It talks about distribution of unsold assets. So,
Either,
So good point, Ajay.
sir, either it has to be transferred, assigned, alienated, whatever, but you should have tried once and because of its peculiar nature, if you're not able to sell, only then you have to go to the AA for seeking permission.
absolutely, like a contiguous kind of a land which does not have an access. Typically, nobody is going to buy it. So therefore, you can negotiate with creditors. All right, your amount is due. You take this. You do whatever you want to do. But at the end of the day, you have to make an attempt first. And friends, I think one of the important things which Anuradha ma'am also mentioned, I literally endorse that. Particularly in respect of Form H, not only in liquidation, friends, even in CIRP, treat this as a checklist. From day one, keep it before you. I think Form H, IBBI has created a checklist for you. Everyone comes and asks me and ask others, sir, what is the checklist? What is the first step? What is the second step? What is the third step? Well, friends, Form H is your checklist. And I think that's one of the best checklists which has been given. So start from there, start building up, as Anuradha ji also mentioned very rightly, that at the end of the day, it is very difficult to fill the form. Because if you keep on filling the form in stages of your liquidation or CIRP, I think that is the best thing. And then it also makes sure that you're not making any mistakes. You're not diverting or digressing. So I think keep your Form H in the beginning. Jaise hi aapko CIRP work is come, take that Form H and pin it before on a pin board before you. So review it on a daily basis.
One more things I wanted to add, sir.
Yeah.
Suppose you are the second or third liquidator who's getting appointed. In that case, also just hold on to your Form H and seek all the information from the previous liquidator as per the form.
Correct. Absolutely right. Absolutely. So what information?
So that it is for your records.
Correct. So it is your complete checklist. I think that's a full statement from her, and I completely endorse that. Okay.
There is a question in the chat box, Geeta ma'am. It was posted quite a long time back by Suchita Gupta. Though it is not related to our topic, but it is very relevant. She's asking if email ID which was created by IRP is hacked by someone in this situation, what is required to do by IP? It is happening.
I think when Suhasini mentioned that you have to create a process email, I think this question popped up at that time. So I think if Suhasini can answer it, it is good. Otherwise, what we are planning to do at IPNet, friends, we are going to have 2 important webinars on different subjects. One is on cyber frauds, I think, which IPs are getting affected to, and 2, we are also going to have, which Parag is going to announce in a little while. I don't want to jump the gun on that. Okay, yes, Suhasini, can you answer that? If the email is hacked, then what needs to be done? You're muted, man.
Yes, sir. Sir, actually, when we create the email ID, we have the mobile ID and also recovery email will be given. Usually, IPs are opening in Gmail. Maybe if the email is hacked, I am not really practically experienced that.
Because, sir, if you are creating an email ID in Gmail, there is a 2-step verification which is possible, sir. One, you can use your email ID, the general email ID, and also your mobile phone. If something goes somewhere, we will always be able to get back the ID.
Correct,
as far as the Gmail goes.
It's little difficult to hack, sir, until and unless usually in our case, I'll be sharing my password with my team members. So one of the team member left and he was trying to, I am based at Hyderabad. One of the team member who left the office, he's trying to log in from Noida. So I got a alert that someone is trying to log in in Noida. Then I sensed it was the same guy. I sent him WhatsApp. He said, yes, ma'am, I am trying to log in. So it's little difficult, but however, if it is hacked, Maybe I think someone IT or cyber experts from our group can answer.
I think two things have to be done. Number one, on a preventive side or a precautionary side, which Geeta ma'am mentioned, start you see putting up a two-factor authentication. It always saves your these kind of hacks and all that. Hacking is possible and hacking is much easier. It's not difficult nowadays, but we have to take precautions. The second, friends, is the backup. Assuming that is hacked, because hacking may happen, right? So you may face such a situation. So then you have to salvage. Now, how do you salvage? Supposing you have lost all emails, somebody has already deleted it. What do you do then? So what I suggest is should not open one single email. You should have two email IDs, right? One you can say CIRP dot so and so. Second, you can say backup CIRP dot so and so. So when you want, what you need to do is in your CIRP dot email, go to that forward settings and forward that all your emails, whenever they jump in, they will be forwarded to another email ID. So therefore, at least you will not lose your data. That is what you can be rest assured of. Otherwise, what the other guy, if he has hacked it, what he can get it? Tell me. Unless you have stored some bank passwords there. Otherwise, that guy is not an IP. What he will do with CIRP?
He's not getting anything what the hacker will.
Sir, a typical situation we have faced, sir, where
Right.
the email ID pursuant to the liquidation process was created in the name of the company itself. Like, maybe I can just take the name. It was XYZ at Deloitte.com.
Right.
When I took over as liquidator, they refused to share that email ID. They say it belongs to Deloitte.
Correct.
So,
No,
I mean,
I'll tell you this also happened in one of the cases when the IPs were not really aware. In one of the beginning cases in 2017, in a real estate matter where 1,500 home buyers were there, now that IP gave them his personal mail ID, right? Like say Ashok Kumar at gmail.com. Now, when the new RP he was replaced by another RP, then the RP asked for all the data. He said, "Sir, it is my personal email ID, where my bank accounts emails are also coming. How can I share?" Then we moved an application, and then the Ben said, "Look, you should have created a separate ID because this is that. But anyway, since it is your personal mail ID, you make sure sit with the IP and forward all the CIRP mails to another email ID." Because it was a very huge job actually. So friends, this is a very good suggestion.
Sir, I have a couple of points to share additionally.
Yes.
See, when you are handing over, because I'll tell you what we did when we were handing over as RP to a liquidator or IRP to a liquidator. We took backup of even the process email ID before we handed over it.
Correct. And
we took the entire ID, and there is a software which through which you can open it. There's a software called Thunderbird. So you can take a backup of run through it, and you'll be able to access all the emails, all the annexes, everything.
Geeta
So
ma'am,
that we learned in one of the process.
Geeta ma'am, you don't require any software. Google has already got a facility where you can save it on your wherever you want to do it. You can download from Google this thing itself. We are doing it because what happens is in many cases the box also becomes full, right? Sometimes it is 15 GB. So you have got a lot of annexures and attachments. So then in that case, what you can do is you can remove those emails, but you can save it somewhere else, which will open in any other Gmail ID. I think the Google has already got that facility. You don't require a separate software also. But anyhow, what you said is also right. Yes.
No, that is when we are handing over the whole processor. See, we'll have to run the entire backup and keep it. So you take the data dump, and then instead of creating a new Gmail ID,
No, data dump can be taken in Gmail itself. You don't require any software.
Yes.
So Google will Google will always
Sorry.
create a dump for you where supposing you want to bring it back in another email ID, it is possible. Anyhow, I mean, whatever way it is, it works for everyone. I think they should do that. But the idea is keep a backup. That's important.
Couple of questions in the chat box. Mr. Venkat Raju has asked, can you inform the regulation which stipulates information to statutory authorities? I think this question is to Anuradha ma'am.
No, there is no such regulation. But because even I tried to find out under which regulation or section are we supposed to inform, there is no such thing.
Yeah, there is no regulation to that, but let us read it with a clear eye that you see column. It says intimation to the statutory authorities if required.
As applicable, yes.
Now, I will read as a lawyer. Friends, may I request everyone to just mute if you're not speaking? Yeah, thank you. So, the point is, supposing like income tax laws require that intimation should be sent to the income tax authorities. So, should I read it? I mean, I'll have to examine it. I've not examined this from this angle. Maybe in over a period of time, we'll do that. We'll have a discussion on this also. It's a good point. But prima facie, my view is that if the intimation is required to be done under any law, under IBC, of course, we are aware it is not required. So if under any other law, supposing we have to inform the PF authorities or GST department, then of course, the date of intimation has to be mentioned. If it is not required, then I don't know whether the liquidator should be going out of way to send an intimation. Well, you may do it as a good practice, that is all right. As a good practice to invite claims, that is all right. That is always helps. But whether it is statutorily required, I'm not very too sure. I will not like to comment unless I go into detail into this. And Radhaji, what we can do is we can connect on offline and we can have a discussion on this, yeah? Right. So I think that's a good point.
Suhasini ma'am, you have to post you agreed to post your email ID. So Mr. Himanshu is waiting for your email ID to be shared in the chat box. Okay, and thank you both of you, Suhasini madam and Anuradha Bisani, for a wonderful presentation within a short span of time. You really did justice to the topic that you committed, and it was really amazing. So, as a token of appreciation, there is a memento from the sites from the IPNet site. I'm just sharing to both of you in the screen, and it will be delivered to your house.
It's a great honor, ma'am, being part of IPNet and transition group.
This is for Anuradha Bisani.
Thank you. Thank you so much, madam.
And I'm doing that for Suhasini ma'am.
Geeta ma'am, you mentioned that it will deliver to their house. So make sure it is delivered.
Yeah, sure.
Yes, sir. It will be. Sorry. It will be done. It will be done, sir. It will be done.
No, I'm saying something else, not to their office or to their house now.
We'll take it, sir. We'll do that.
Okay.
Thank you, ma'am.
Thank you, sir.
Thank you,
Both of you. And over to
Mr. Parag, actually.
For the next announcement.
Okay, thank you very much. Friends, on 25th of January 2025 at 4 p.m., IPNet is coming up with a webinar on the topic Creating Safe Workspaces in Insolvency Practice, Understanding the POSH Act and its Relevance for IPs and IP Offices, with Ms. Harmeet Kaur, IPN Advocate, as the lead speaker. All of you are requested to join in large numbers in the webinar on this extremely relevant, however, least touched upon topic by any of the known forums in the IP ecosystem. The joining link will be shared soon. Thank you.
Okay, Parag, can you share the full form of POSH Act? Because some may not be aware of that.
Yeah, POSH is Prevention of Sexual Harassment Act.
Yes. I think we chose this topic particularly because IPs are also supposed to take care of that. So because if you have a large IPE or an office which are employing number of employees are there, I think the requirement of POSH Act is extremely crucial because tomorrow you can be in trouble if you're not formed a committee, POSH committee or something like that. So I think it will be a great knowledge, good knowledge for all IPs to comply with the provisions of that law. Okay. So thank you. Yes, I think we can move forward now.
Yes, Paragji.
Yeah, I have been assigned duty to extend formal vote of thanks on behalf of IPNet. So good evening, everyone. It is an honor to extend the vote of thanks for today's webinar. Today's event has been a great learning experience for all of us so far as the compliance certificates in CIRP and voluntary liquidation. Am I right, sir? Voluntary liquidation are concerned.
It was only liquidation and CIRP.
Liquidation, right, ma'am. Liquidation are concerned. First and foremost, I extend my heartfelt thanks to Shri G.S. Narasimha Prasad, Managing Director, IP ICMAI, our esteemed chief guest, and to our distinguished keynote speakers, Swasni Ashok B. ma'am and Anuradha Bisani ji, for sharing their profound insights and practical perspectives in filing of the compliance forms under the IBC. The assurance by our chief guest that with the soon to be introduced new forms, the submission of data repetitively will be reduced is a great relief to all the IPs. Thank you to each one of you for sharing your time, wisdom, and experience. I would like to express my gratitude to our IPNet President, Dr. Ashish Makhija, Ashish sir, your commitment and visionary leadership have made IPNet an exemplary initiative and a platform of great significance for insolvency professionals pan-India. Thank you for being a guiding light to all of us. Special note of appreciation goes to our moderator, Geeta Sridhar. Ma'am, your valuable insights and the smooth conduct of webinar have greatly enhanced today's discussions. A special thanks to the invaluable contributions of transition and the technical support teams. Their seamless coordination and tireless efforts behind the scenes ensured a smooth conduct of the webinar. Our gratitude to all the participants who joined us today. Your enthusiasm, active engagement, and thought-provoking contributions have truly made this event special. And last but not the least, our sincere thanks to Regional Director IPNet South, Mr. T.R. Ravichandran, for ensuring the success of the webinar. Thanks to all of you once again.
And friends, one last word. All previous recordings of previous webinars, I think Tina was also there. She conducted one of the wonderful webinars. I think all webinars are uploaded. The recordings are there. If you have missed on any subject, please go there and watch those. You can watch those webinars also. Thank you so much.